So Arash, as we said in previous episodes, when you buy a property from the secondary market, from the resale market,
Yes.
you will have your broker, you will engage with the seller under Form F, which is a land department template, and it will have an addendum to
Correct.
it, where you stipulate all the other conditions.
Right.
Such as the default clause.
Absolutely.
So
right.
if that agreement says the buyer placed 10% security deposit, the seller placed 10% security deposit. Now, let's say the seller backs out,
Okay.
okay? But the broker refused to give me the check of the seller,
Right.
the security check of the seller.
Right.
Let's wear the broker hat, the buyer hat, and the seller hat.
Okay.
Okay. So what are the rights of each of these parties? Does the broker have the right not to give the security deposit? Because in most cases, broker says, "Go get me a court order."
Correct.
And can the buyer sue the seller for this? And can the buyer actually sue the broker too?
Okay.
So what do you have to say about this?
See, the situation, it's a complicated situation, but it can be dealt with in a very professional way. The main responsibility will be with the broker. The broker has to make sure that all the communications happens in writing, that they can prove to the court that who is actually the defaulted party. And that you can only prove if
But
you have the documentation.
before going to the
Yes.
court,
Yeah.
let's say now the seller defaulted already, and the buyer came to me says, "Give me my security check,
Right.
and give me the seller security check," because
Correct.
the seller lost the 10% because he backed out.
Right.
Okay. What is
Brokers.
a best practice?
See, brokers, they
have to-
don't. See, they don't, and
But
they
as
have
per the
right.
law, do they have the right not to?
You will have the right to return this check if the buyer and seller agree on this.
Okay.
To return the checks.
Okay.
Okay. If not, then broker, in order to protect themselves, they would say that no, go to the court, get me a judgment, and then only I will return the check.
Okay.
But then you need to pay attention that they will go to the court and they will sue the broker as well as the defaulted party.
Great.
Because they have the check with them.
But here, this is a really important point. So even if the contract, the sales and purchase contract, which is Form F, states clearly that the broker has the right to release the security check to the other party, the
Right.
security check of the defaulted party to the other party, and none of the parties have the right to sue the broker.
Right.
Will the broker be still subject to a legal case?
Yes.
And will the broker still, but does the broker have the legal right to release the checks if that's what the contract says? Because like you said in previous episodes, there has to be some respect to the signed contracts,
Absolutely.
right?
There is one big question mark here.
Yeah.
Who is in a position to say that actually that defaulted person is actually in default? It's only the court who can decide about that. Only the court has the right to break a contract if it's not agreed to be broken on an amicable basis.
Okay, all right.
So that's why the broker, in order to protect themselves, they would say that no, I with all due respect to all these, you need to go to the court and get me a judgment, then only I will release the check.
All right. I think that's clear for buyers, sellers, as well as brokers.
Yes.
Thank you very much for watching. Please feel free to leave all your questions in the comment section below, and I'll try my best to address all your concerns and questions personally. Feel free to tag a friend who may need to learn more about the real estate market, especially in the legal context. And of course, don't forget to follow any of my social media accounts that are mentioned below. Stay tuned for many more to come. Thank you.